Hello, and welcome to the latest version of the Indiana Healthcare Executive Network's podcast. I'm Randy Pritchard. I'm a member of the IHEN board, and I chair the Communications Committee, and will be facilitating today's discussion. The recent change in Indiana law regarding pregnancy termination affects healthcare providers and companies as both providers of care as well as employers. Today, we're going to attempt to address some of the common questions about Senate Enrolled Act 1 from both a provider perspective as well as an employer and an employee benefits perspective. And I will add, we certainly recognize the sensitivity of this topic. Our goal here today is to provide information about the latest updates on the ongoing impacts and the change of law so that those in healthcare can make the best decisions. I'm pleased to have with me for this discussion Taryn Stone and Shalina Schaefer, both with Ice Miller. Before we jump into the content, I would like to take a moment to thank our sponsors who make all of this possible. Ice Miller is the premier sponsor for IHEN. HEPI is our platinum sponsor, and our gold sponsors are InnovCare, Cat Sapper Miller, Cornerstone, and Arc Design. So with that, let's start with introductions. Taryn, would you mind introducing yourself, please?
Sure. My name is Taryn Stone. I'm a partner at Ice Miller, and I'm the chair of our healthcare group at Ice Miller. I'm also on the board of IHEN. I'm serving in my first year.
Great. Shalina, your turn. Would you mind introducing yourself?
Sure. My name's Shalina Schaefer. I'm Senior Counsel in the Workplace Solutions group at Ice Miller. I've been working there 14 years now with a focus in employee benefits for health and welfare clients as well as retirement.
Great. Thank you both. And as I said before, my name is Randy Pritchard. I've been an IHEN member for 5 years now and on the board. For my day job, I'm CEO at Pillar Biosciences. We're a next-gen sequencing company focused on cancer diagnostics and monitoring. So with that, let's dive into the discussion. And we're going to start our discussion from the provider's perspective. So to set the stage, can you please briefly provide an explanation of the changes in Indiana law that Senate Enroll Act 1 made to the provisions of abortion in Indiana?
Sure. I'll start with the location of where abortions can be provided. So under Senate Enrolled Act 1, abortions can now only be provided in hospitals and ambulatory surgical centers that have a majority ownership by a hospital. There has been a removal of licensed abortion clinics from the list of places that can be provided. And I will caveat right now, and we'll talk about this, I think, a little bit more later, but there's currently an injunction in place as of the time of recording. So we're going to talk about what SEA 1 does, knowing that currently it is not in place. The second change is that there are no kind of what I'll call elective abortions. All abortions are criminal acts in Indiana now, except when performed under limited circumstances. Those circumstances are to save the pregnant woman's life, to prevent serious health risk. And I think it's helpful if I give a small definition of kind of what that might include. So it would require a physician in their reasonable medical judgment to determine that a condition exists that has complicated the mother's medical condition, and it necessitates an abortion to either prevent death or a serious risk of substantial and irreversible physical impairment of a major bodily function. And it's important to note also, it doesn't include psychological or emotional conditions. So it's a physical condition. Lethal fetal anomaly is another exception to the rule. And that is where a fetal condition is diagnosed before birth, that if the pregnancy results in a live birth, there's some reasonable certainty that the death of the child will occur in the first 3 months of life. And then the last one is rape or incest, and that one is time limited. The other ones are not time limited. It can be done at any time. But it's during the first 10 weeks of post-fertilization age, which for most women, that's 12 weeks since last menstrual period, which is really kind of the way that pregnancy is measured. So 12 weeks of pregnancy. And then it's just as a caveat as well, it's important to remember in Indiana specifically that the restrictions are on the providers that are performing the abortions and not the patients that are seeking the abortion. So currently, all of these laws are focused on the provision of an abortion by a provider, not on the woman who is seeking one. And then finally, and we can talk more about this in detail, but another key change is the addition of some documentation requirements and certifications. And so within the medical record, before an abortion is performed, the physician has to provide a certification And this kind of created some confusion initially as to what this might be, but it's a certification to the place where the physician is providing the abortion, that in their judgment, in the physician's reasonable medical judgment, that it's necessary to do one of the things I mentioned, either prevent death, that there's a serious health risk, that there's a lethal fetal anomaly, or that the pregnant woman is the victim of rape or incest. And all facts supporting the certification that they're making has to be set forth in writing by the physician and attached to the certificate. So in theory, that's contained within the medical record and not only present in the medical record, but in the certification, the physician has to go to some length about why he or she has determined that one of these factors exist, that it takes them outside of kind of the overarching prohibition.
Got it. So as an Indiana provider, how does Indiana's new abortion law impact our providers' provisioning of obstetrics care?
So I mentioned the certification. That's definitely a new requirement. Again, most of our providers, or all of our providers in the state, given where we are with medical records, are used to kind of documenting the medical record. But this type of a certification, almost similar to an affidavit, is definitely a new requirement. So that they're going to have to document the facts and circumstances. Some things that have come up are, physicians are questioning how can they document rape or incest, right? I mean, there's not, if the person is already pregnant, it's not like that has just occurred. And so there's some reasonableness of just saying that they've talked with the patient has reported that they're a victim of rape or incest, and then documenting the facts that the patient may have shared with the physician, for instance. Additionally, the level of detail provided for the reason of abortion has to be included because this is now a required element of the termination of pregnancy reports. So there's what's called TPRs that have to be filed with the Department of Health. That's existed pre-SCA1. But now you have to list the reason for abortion since there are now only limited circumstances where that can be provided. And because these are publicly available documents that can be subject to Indiana's equivalent of FOIA, it's called APRA. It's the Access to Public Records Act. They want to make sure that the level of detail is robust. And often some of the concern is because now you have potentially non-medical providers, right, prosecutors, et cetera, who may be reviewing their determinations kind of post-decision. And so it's important to go into the level of detail of things like volume of blood loss, to the extent there's a inevitable miscarriage, the location of the fetus in the birth canal, things like that, blood pressure readings if it's preeclampsia, that kind of thing, and how that deviates from what's normally seen, and just the physical symptoms being experienced and the effect on the mother's life should be documented. Additionally, and again, most of these have existed in Indiana law, so it's not necessarily a change. But there are substantial requirements on the physician for counseling and documentation in any event when an abortion is being performed, which includes the provision of pamphlets and state-issued forms, things like the offering of an ultrasound within prescribed timeframes, things like that. So we've been working with providers to make sure that they're working diligently to understand what the requirements are and to make sure that all required forms are provided and the medical records are documented accordingly, especially in the light of the certifications that are now required. So things like there's an informed consent brochure put out by the Department of Health. A color copy has to be provided to the patient. The name of the physician, medical license number, 24/7 phone number to reach the physician has to be included. Risks and alternatives to procedures, healthcare providers know that's informed consent process. A picture of the fetus and dimensions at the gestational age in which the abortion is provided. Things like availability of benefits for care in childbirth. That the physician has to tell them that the father has to provide assist in the care financially of that unborn fetus, and a form regarding the fetal disposition of remains. And I have not hit all of them. There's upwards of 20 things that the physician has to walk through, but providers, given what's at stake with licensure and medical licensing board actions and things like that, we've been working with providers to make sure that they have good processes to make sure all of these things are done. And then finally, as we know, there's a lot of nuance in medicine. And so Indiana's passage of SCA1 was in a special legislative session, and it occurred pretty quickly. And any legislation that gets passed, there's often revisions that have to occur post passage, because you start to apply it, and then there's some confusion or clarifications that need to occur. And so things that maybe historically would not have been considered abortions by medical providers, things like when an action is being taken to save the mother's life. A lot of providers may not have reported that in the past because there's no intent really to terminate the pregnancy. The intent is really to save the mother's life. Given what's at stake for not reporting, a lot of the providers are erring on the side or prepping to err on the side of reporting those procedures. And so again, it's they're kind of creating internal processes to make sure that they're considering all of those things when making the report. Like I mentioned, there's concern about hindsight and second guessing in emergent situations, because a lot of these are provided either in the emergency room or emergently. And so there are professionals that are trying to put processes in place to make sure they adequately document, given that these decisions may be looked at kind of post, and make sure that they're documenting evidence-based practices. And then this is more anecdotal than anything, but one of the things I think that will likely be considered in legislative session, there's been some discussion about infections and things like cancer that may be exacerbated while providers kind of wait for the condition either to become life-threatening to where they can it gets to that serious health risk bar. Because things like ovarian cancer, historically, the woman has to decide if there would be an elective termination. That's still elective at that point because it's not imminently affecting her life at that moment, but cancer treatment has to get underway. So things like cancer and some of that nuance and that gray area within Indiana, there's some questions from a provider perspective of, does that rise to the level of a serious health risk?
So in your work dealing with providers across the state, obviously statewide practice, can you talk a little bit about what they have been doing to prepare for the enactment, or to comply?
Sure. And so as I mentioned, I think that they've been working to create templates, policies, and procedures, things like that. Another thing that I should mention is EMTALA. So EMTALA is the federal law that deals with emergency care and, what has to be done when a person presents to the emergency room. And again, this is only presentation to an emergency room. So just kind of keep that in mind because it only applies in the context of an ER. But there's some guidance from a federal perspective that preempts state law. And this has to do with, again, it goes to the same thing about documenting the medical record accordingly. But there's some federal protection that physicians are, kind of weighing against Indiana's protection about care that must be provided. So I know that there's hospital legal counsel, hospital executives kind of making sure that they have processes in place when a woman comes through the ER, which is different. So I just wanted to put that out that EMTALA does exist to provide some guidance on that fact. The other thing, I know that there's a lot of education, like ACOG, Indiana, the American College of Obstetrics and Gynecology, and other kind of national associations are doing education of their members. I know legal counsel within organizations and health systems have been working with firms like us and others to make sure that they're prepped and ready to go when this, and it was implemented for at least a few days to have policies and procedures in place. Other best practices, and this rings true regardless of where you are. This is not specific to abortion, and it happens. It's just best practice. Contemporaneous documentation of medical necessity at the time of treatment. You don't want to be going back into the medical records because then it seems like you're kind of supplementing after the fact. So we always counsel kind of contemporaneous documentation, and then contemporaneous documentation of evidence related to the satisfaction of the elements to meet the exception. So like I mentioned, there's a certification requirement, but also you want all of that to be done. And there's some exceptions for emergent, like they're not going to be documenting the medical record while they're treating the patient, but quickly thereafter kind of going in and making sure that the evidence in the medical record at the time of treatment or as near to it as possible kind of gives sufficient detail and justification for the procedure. We've worked with several clients to explore templates or checklists within their EMR systems, which is kind of the benefit of having an EMR system to make sure that they are doing all of the appropriate counseling and informed consent requirements, and that the forms are being given, signed, et cetera. I mentioned creation of policies and procedures as another. And then I want to call them timeout sheets when not emergent. And then, creation of kind of peer review type reviews being done where physicians consult other physicians. Because I think it's helpful evidence that it's reasonable if you've consulted other physicians. So I know the IHA, the Indiana Hospital Association, has really helped lead some of these discussions within especially smaller hospitals to say, hey, you can even create some peer review groups kind of between the hospitals or some outreach networks so that if you're seeing these things, you can be consistent in how they're being treated and have a resource of someone else to reach out to or a second opinion. And I know physicians do that pretty frequently anyways, but that was just another idea that was thrown out there to make sure that that all available facts are being kind of considered and documented accordingly.
Great. So we know that there is currently an injunction in place, right? So we went into effect for a couple of days and then the injunction happened. Can you kind of update everyone on where things stand? What's the status of the injunction and what are we looking at as this plays out going forward?
Sure. And I'm going to read from my notes a little bit because this is very civil procedure technical from a legal perspective, and I'll try not to bore anyone. But on September 22nd, so Judge Hanlon issued a preliminary injunction that paused SCA 1. And as such, all the law that I just went through about the changes was kind of put on hold. And interestingly, there had been an action before called a temporary restraining order. There was a motion for a temporary restraining order before the law went into effect, but there wasn't enough time. So that was denied. But then this preliminary injunction was granted after there was a hearing on the case at the trial court level. And she granted the preliminary injunction. And in doing so, she noted that there was a constitutional question under the Indiana state constitution about how the Indiana constitution treats the concept of liberty and the right to liberty, and found that the burden on bodily autonomy and other things in existing case law could be in question as it relates to the women and children in Indiana and the kind of limiting of what she termed access to care. And so she noted in granting the preliminary injunction that that we couldn't let this continue, right? That the remedy at law is inadequate. We have to, there's irreparable harm that could be suffered, so that there's a question that needs to be decided by the court. And so therefore the preliminary injunction was put into place. She granted it. And she said that any harm of not moving forward is outweighed. And so the AG then appealed that and said, well, no, we want this to be set aside. And then the Supreme Court stepped in. So it would have gone to the Court of Appeals. The Supreme Court stepped in and said, we're going to grant transfer. We're going to put that this is a constitutional question. This is a question that we, the Indiana Supreme Court, should weigh in on. And they granted transfer of the issue to the Supreme Court so that it doesn't have to work its way up. And that they'll hear oral arguments on the case. And so the briefing is currently being done. The state, I'll call it the state, the licensing board, the prosecutors, et cetera, their brief is due November 1st, so next week. ACLU's brief is due December 1st, and then there's a reply that is December 16th, and oral arguments have been set for January 12th, 2023. So we know at least from now, there's some certainty for providers, at least between now and January 12th or sometime after that the SCA 1 is paused. And I should also note there's another case that is out there that is still sitting at the trial court level, but that no action is being taken on yet. And that is ACLU's case alleging violations of RFRA, so Indiana's Religious Freedom and Restoration Act. So that's a separate case from the one that we're talking about. And I think it's also important to note that we expect this to be, as it was in special session, which was it was the sole kind of this plus the refunds that were given to taxpayers. We expect this to continue to be a topic that's kind of top of mind for the Indiana legislature, and that would be likely discussed at length with likely some additional revisions coming in the next full legislative session.
Revisions, clarifications, and obviously depending on what happens at the court level.
Absolutely.
Yeah,
and
right.
We expect that providers, in doing all this prep work, as I mentioned, there's a lot of nuance. We expect providers to be more, and I know that they're working on some of that now, just asking for clarification, saying this is the stuff we're worried about. This is the stuff we need some clarification from you, the legislature, on. And so we expect that to be taken up.
Great. Well, thank you for sharing for that from the provider side. So now let's switch
Sure.
to the employer perspective. So as an Indiana employer, how does this new abortion law impact our employee-based group health plan coverage of abortions?
Right. So this is a question that a lot of our clients have come to us in the last few months, really since SCA 1 came about with the special session. And in answering it, the first thing that we look at is the funding, the way the plan is funded. So to break it out into two categories, we have self-funded plans. So usually, typically larger employers will self-fund their benefits rather than going through an insurance policy, funding it through an insurance policy. And when they self-fund their benefits, from a state law perspective, there's nothing in SEA 1 that requires that the employer change their current level of abortion coverage, increase it, decrease it in any way to align with SEA 1. So really, self-funded plans have a lot more flexibility under the law. Part of that's because of ERISA preemption for private employers, but also because we don't have to worry about the insurance code provisions that would apply to fully insured plans. So on the other hand, when you have a fully insured policy, so smaller employers will typically always fully insure their group health plan coverage, then any policy underwritten in Indiana needs to be approved by the Indiana Department of Insurance. And although there is not anything that changed with the group health insurance policy provisions under SEA 1, there's some uncertainty in the law right now because, as Taryn was saying, this went through very quickly, and the way it was drafted, we're expecting different revisions and different things to be looked at. And it's our understanding that the Department of Insurance might be looking at those policies differently at their next renewal in light of the changes in SEA 1. So really, fully insured plans, the employer is going to have to go to the carrier and ask what kind of options are going to be allowed with the policy. Typically, there won't be any change until the next renewal, but to kind of just talk to them about that. And then as a practical takeaway, whether you're fully insured or self-insured, the practical perspective, a group health plan cannot pay for illegal services. And so assuming SEA 1 is unpaused, right, plans can't cover abortions that aren't legal where they're provided or if they're outside of the licensure requirements of the physician. And so as we know from Taryn going over SEA 1, it places new and somewhat significant new restrictions on Indiana providers' ability to perform abortions. So even a plan that's designed to have abortion coverage without restrictions in the plan document, for as far as Indiana residents are concerned, they would have to go out of state to get that coverage.
So I guess that's the next natural question, right? If a group health plan pays for abortions that are legally performed in other states, but would not be legal if they were performed here in Indiana, does that coverage put that employer or that group, that sponsor of that plan at risk?
Right. And so SCA 1 and nothing else in Indiana law, for that matter, governs out-of-state conduct with respect to this issue. So an employer is not prohibited from providing coverage related to abortion services in states where that coverage is legally performed. We have seen legislation in other states, namely Texas and Oklahoma, that appear to go a bit further in granting private citizens a civil right of action to go after anyone who aids or abets, it uses that language, aiding or abetting an abortion through insurance or otherwise. And so it specifically raises the issue of abortion coverage through insurance. Even those laws, they're not being read broadly enough to apply to out-of-state conduct. And in Indiana, SEA 1 did not take up or adopt that language. And so we don't see a current risk of civil and criminal liability for a practice that has pre-existed SEA 1, where abortion coverage is more broad under the policy or under the plan than state law permits.
So let's play this now to the next level, right? Several large employers, very publicly announced that they will provide travel benefits to employees that live in a state, in Indiana, for example, to go to a state where abortion coverage is legal. So now, are there legal concerns with taking that approach here in the state?
So employers are not prohibited under Indiana law for providing travel benefits to Indiana residents to receive abortion services out of state. The question has come up around how to structure these benefits. How do you do it in a way that doesn't implicate other laws? Make sure that we're following HIPAA privacy laws that apply to providers, but also to health plans in the way that we get this information and run these kind of more ancillary benefits with travel. For self-funded, I'll go back to that dichotomy. For self-funded plans, the easiest approach to adding travel benefits is to talk to your third-party administrator and to do it through the health plan. Many larger TPAs have already designed these sort of standard travel options in response to the demand for this, which employers could choose to add on to their plan. These are typically structured in a way that would reimburse travel expenses incurred by the employee or a dependent to travel expenses that are necessary to receive covered services under the plan. So a couple points in saying it applies to covered services. One is that TPAs generally will not add this travel benefit option for travel related to non-covered services. So if your plan has restrictive abortion coverage currently and you're thinking about adding travel, you might need to expand your abortion coverage, the underlying coverage under the plan, in order for a travel benefit to make sense, because they will not pay for travel expenses for an abortion that's not itself covered under the plan, if that makes sense. We've also seen that TPAs offer to either provide a general travel benefit for medical care that's covered under the plan, or an abortion-specific travel benefit, because this is the issue driving it, so some employers are asking just for that. There are some concerns around making it solely for one type of benefit that come up under mental health parity rules, because under federal mental health parity, you're supposed to be offering any mental health and substance abuse benefits in parity with the way you provide medical and surgical benefits. And the issue would come up if, for example, your plan covers some mental health benefits that are not available locally. Somebody would need to travel for them, but the plan doesn't cover that travel, and they would cover the travel if it was for a medical or surgical procedures, including an abortion. And so to sidestep that concern and the analysis under federal law, typically, because the costs here at issue, when people are pricing these are not significantly expensive benefits to add. They're typically looking at offering a general travel benefit. This also sometimes helps employers in the way they wish to communicate the benefit to employees. If they want to say, we are enhancing our benefit program by offering travel benefits, they can sidestep maybe more sensitive conversations by making it a general travel benefit. Other things to note with travel benefits, they are limited, to have travel benefits be tax-free, they're limited by the IRS limits, which typically will always be enforced under a plan so that you don't have to tax benefits above that limit. And that includes $50 a night for lodging. And these aren't big benefits, but $50 a night for lodging, up to $100 if you have a companion. So if a minor's traveling with a parent, you could get $100 tax-free lodging per night. And it also reimburses direct costs of airfare, and rental cars, mileage reimbursements if you're driving. But it doesn't reimburse meals, and it's pretty much limited to those expenses for the travel and the lodging. And on top of that, the employer could put in an annual dollar limit. So they could say, we're going to offer travel benefits for services not available in your immediate area or in your state, limited to the IRS limits, plus limited to some $1,000 a year. So that's all within a self-funded plan. If you have a fully insured plan, typically this is not going to work in Indiana. Or if you have a self-funded plan where your TPA is not able to administer travel benefits, and you're still looking to offer travel benefits and ways to assist your employees, you'll have to look at, there's a couple different design options you can consider outside of your plan. One would be it's called a health reimbursement arrangement, and it's sort of just reimbursing for eligible medical expenses. That's employer funded. You could set that up to reimburse not only for abortion services, although that's taking it a little further than a lot of employers are looking at, but you could use it to set up for travel reimbursement. The issue would be finding the right vendor to administer it due to the privacy nature of the documents and the fact that all travel expenses have to be substantiated. So the person has to turn in the receipts and you have to know what the purpose of the travel was, right? So it's all going to be governed by HIPAA. You'll want a vendor that can do that. And if you have high deductible health plans, which many employers have now, HRAs conflict with the rules with HSAs, which is a different type of account, right? Health savings accounts. And so this solution doesn't work very well for clients or for employers that are high deductible health plan set up. The only other option I've seen people looking at in the health context is to expand employee assistance program benefits that they might currently offer if their vendor's willing to administer travel benefits that way.
Great. Well, obviously a highly complex topic. Any last thoughts that you didn't get a chance to comment on as we went through this?
No, I would just say stay tuned because I do think, like Shalina's mentioned on the insurance provisions and like I've mentioned on some of the provider related provisions, there are likely to be substantial revisions yet to come. And I imagine this is going to be a topic that is focused on in the next legislative session. So this podcast or video may be outdated pretty soon, but we'll continue to provide updates as we follow them.
Absolutely. Well, look, I want to thank both Taryn and Shalina for very insightful, background information. As we said, obviously we recognize this is a very sensitive topic, and our goal here is just to provide information to our members as they're working through these incredibly challenging issues with the passage of this new law. And so, obviously, Taryn and Shalina do this every day, and they are certainly available for anyone out there that's looking for advice and counsel through Ice Miller. And I want to again thank our sponsors, and obviously our platinum sponsor, Ice Miller. Great to have you here with us today. Heapy, Innov Cat Sapper Miller, Cornerstone, and Arc Design. And thanks to all of our listeners for joining us. And I wish you a great rest of your day.